Up here.
Anybody else?
All right, good afternoon. This is our Tuesday, November 12th, Henry County Board of Ethics meeting. Here in our conference room, start with the roll call. District 1 is vacant. District 2, Samuel Valme, present. District 3, Lauren B. Smith.
Present.
District 4, Vice Chair Harold.
Here.
All right, District 5, I'm Desmond. Tax Commissioners appointees, Cynthia Cornock.
Present.
Antonio Taylor is absent, and we have our two new members, alternate members, Ms. Benita Harris
Present.
and Ms. Erica Pike. Welcome. Harris. Okay. If I can get a motion for item B, board vote for approval of meeting minutes for 10/29/24.
I make that motion.
All right, motion made by Lauren Smith. Second by Samuel Valme. All in favor? Any opposed? Do we need to make a motion to table C or we?
Yes, Chair.
All right, if I could get a motion to table item C for our general update by our ethics administrator.
I make that motion.
All right, motion made by Samuel Gomez,
I second.
second by B. Smith. All in favor? Any opposed? All right. And now we'll have our general updates by our ethics officer.
Thank you, Chair. Good afternoon. In regards to general updates as it relates to training, since we met last, we've trained 34 new employees that have come and welcome to or being welcome to Henry County. We have gotten the updated information from technology. We have been working with NAVIX to have that updated so that we can send out those beta testings. So that is still in the works. Gloria has began getting dates for next year for live trainings. This was off year for live training. So next year we will do another round where everybody has to do live trainings again. And so we're looking at securing dates for that as well. Those are all the updates as it relates to, oh, no, it's not one more. I have before you all what we're going to start pushing out. Gloria and I are going to every department with the holiday season coming up to talk about gifts. We're going to be giving them a feel on what they can and cannot accept. This is a season for giving, but that doesn't mean they can receive. I'm also going to be seeing if they have break rooms, posting this in the admin, more of an informational and a friendly reminder as we're approaching the holiday season, what they do and do not need to do. So this is part of our training efforts to make sure now that we're coming upon it, that just a friendly reminder of the code and what the code says as it relates to training.
Question about
Mhm.
this. Is this only enforceable due to the code, or they have internal mechanism to talk about this within the county government?
Both. So the county has its own gift giving and receiving policy. This is the code itself. And when they are trained that there are two different things and you have to abide by both. The county's policy is actually stricter than the code itself.
Okay, thank you.
You're welcome.
So we're going to be the Grinches that stole Christmas.
We may.
Okay, all right.
Yes, ma'am.
What about sending this through like the email?
Yes, ma'am.
It informs, make sure everyone does at least receive it.
That was the plan too.
Oh, okay.
To send it on almost like an e-blast.
Yes.
And then as well as to go to the department to see if we can put them somewhere. If they let us, I don't know how successful we will be in this. If they have some type of luncheon during Thanksgiving time, that will be a time for us to go in and say, hey, just friendly reminder from the Board of Ethics, but I doubt they probably let us do that. But agree, yes, the email was on the list as well.
Okay, I apologize. I didn't hear that.
No, I didn't say it, but
Okay.
it was in the brain. Yes.
Question, should we also put language on this flyer reminding them that there are stricter rules that apply as it pertains to human resources? So they won't just see this and think this is the one and only rule they need to abide by.
What I would probably do, if you want me to add some language, I'll say there are other rules that need to be reviewed. I never get into what those rules are.
Right, you
But
don't
I
have
can
to,
definitely
yeah.
mention it. Please also check with your Henry County Policy Handbook for further rules.
Yeah,
Okay.
One other question. You mentioned that the county rules is more stringent than our rules. My question is whether or not we're in conflict with our $100.
We are not in conflict. So when the code first came out, I had a meeting with the county attorney at the time because that was one of the contentions between what the county policy was and what the code said itself. And that's when we discovered that the policy of the county is stricter and it's actually stricter in monetary value. So for the county, it's $50, but for the code, it's $100. So when I'm training them, I tell them, if you're following your county policy, you're more than likely already in compliance with the code itself.
so in other words, an asterisk should be placed by the
Yeah.
$100 with language in the bottom, reminding them to check their handbook or policies. Because it is $50 and it is obviously half the price.
Yeah, that is a conflict.
Yeah,
And I asked them, if they would adopt their policy to what the code is, because code is law, right? So that's the statute that controls, policy can be changes. To my knowledge, they had not changed it so that it can be one streamline, and we can't really force them to. But I do see how people can get confused between the two. So I'll make sure I add the asterisk with the notes and refer them to the Henry County policies in addition to this. Mhm. Any other changes or commentary, clarifications? Criticisms? Okay, that is all the updates as it relates to training, as it relates to case updates. As you all know, we had a delay in hearing, final hearings up until we cleared up some administrative issues. We have been 100% caught up on all final hearings. There are no outstanding final hearings that need to be heard, as of today. So we are just good on all of our cases. Now, we are still waiting on the transcripts for both cases, which is why you still don't have a final order in front of you all. But what I did go ahead and do, I gave Chair 2 letters per the board where you all wanted to contact Parks and Rec about their policies and procedures regarding commissioners, reserving venues and things of that nature. And I went ahead and drafted a letter to Parks and Rec and
Human Resources.
Human Resources in regards to Mr. Munez having a little more training in that area. Now, I drafted them so they can be ready with the order. We had discussed, and I still believe that we need to send a copy of the order with the letters so it can make sense, but we just haven't gotten the transcripts.
What was went to contract with the company for the transcripts? I thought there was a certain amount of time they had in order to turn those around to us.
I'm not sure, that was with Gigi. She would have the most updated information. I did ask her what the most updated information was. And so she told me, and they actually emailed, let's see, she emailed me today as well. Miss Vicky Ezel is one of them. She didn't say a time specifically that we would have it. That was for the Thomas case. And then the other case was for the other court reporter was Ms. Rena. Now, Ms. Rena did email Gigi on November the 7th and said that she was in trial and that she would send it over on November the 7th along with the invoice, but we haven't gotten it to date. So what we have decided going forward to prevent this problem is to go ahead and stream via the Zoom and record it. Whether, yes,
I mean, I understand that. Her point is there's a contract and they're missing the deadlines as far as submitting what they're supposed to submit.
I don't know what the contract is. I didn't deal with that. Gloria did.
Yeah, but I just want us to hold them to whatever they said they were gonna do, because I don't recall it being this length of time.
It wasn't.
It should not have been. This is a very, very long time to produce transcripts. So I'll follow up with her to see what I don't think there was a formal contract. If there was, I'm pretty sure the chair would have had to sign it. And I don't think we've entered into a form, but there was definitely a representation.
That's,
Uh-huh. I'll follow up with her to see what that representation was and what the holdup is.
I'm sorry for cutting you off because you were mentioning that you're going to also record the sessions
Zoom.
through, I guess it's through Zoom.
Mhm.
And my question is, you know, ask that question. You may want to continue your thought, but did you?
No, I was concluded with my
Okay.
business.
Okay, thank you.
Did you want to go back to the Zoom recording?
No, I talk about it at another later date.
Okay, and I will say with the Zoom recording, that was at the recommendation of our hearing officer. He recommended that that's a good and cost efficient way to be able to go ahead and have a record of what happened and be able to refer back to it. Anything else as it relates to case updates? Any other questions?
I have a question. The one that is in the appeal process, what's the latest and greatest?
Thank you. I spoke to Judge Amero. So we did not, before the changes that I've made before you all, had a process at all. And because of that, we were unaware. Right now, his appeal is almost in abeyance. Because there was no written process of what to do. I don't even know if the judge knew that he had appealed. So right now it's in abeyance.
Well, on that question, did they meet the deadline of 14 days?
14 days for what? There was no deadline of 14 days.
It's on the notice.
Although
To
to
appeal.
out the writ,
Right.
if they met the day. Here's the difficulty. The difficulty is when you appeal, you have to serve us. They never serve us. That is the problem. But when I met with or was guided by Judge Amero on the appeal, they just produced a statute, not just, but in 2023, to kind of clarify all of these issues. And one of the things that the code now says, it says that those types of appeals should not be dismissed for those types of technicalities when it comes to timelines. It's given the appellate a little more leeway to be able to get their case heard by a higher court.
Have we actually been served with it yet?
We
though?
have still yet to be served with it.
Have we come up with some pattern of behavior, like some type of system now for them to follow for when there is another appeal?
The code. So now that we know that the statute actually gives away, when we go over our changes in our handbook, it says that the appeal has to be done pursuant to the Georgia statute, and I named the Georgia statute, so people know to refer to that and follow it. The code itself gives people 30 days to be able to appeal. And then it tells them you have to serve the other party. The judge will review it. I would have to do a reply. The transcripts have to be sent up. It lays it out step by step what needs to be done.
I'm still just a little concerned that we weren't notified by the clerk's office.
I agree. That is very concerning.
Because I mean, otherwise we wouldn't even know that it was being appealed if Gigi hadn't been at the courthouse. And I don't really know any way to get clarification on that.
So have we had a meeting or conversation or email correspondence with the clerk moving forward?
I have not. I don't know if Gloria has reached out to her in regards to that aspect. I'm going to assume that she has not, because our order of things to do was first meet with the chief judge and see what the process should be. And now that we have that clarity, the next order would be to meet to her to clarify, this is what the procedure is going to be. How are you all going to implement that procedure on your side? And Judge Amero just got back with us, I think on Thursday last week.
I'm gonna make a motion for us to amend the agenda to include an executive session.
Okay.
Second that motion.
All right, motion made by Sammy Bomay, to go into executive session right after our ethics officers updates.
Hey, I go back to one thing.
Yes, ma'am.
On the transcript, I would recommend that we use the transcriber, I don't know what you call it, recorder, and Zoom at least the first time, because we're so far away. I wonder how much Zoom is actually going to pick up from distance wise, and then especially when we go into discussing the case. I don't know how Zoom is going to be able to pick up on all those. So I just wonder, at least give it one try with Zoom and the court reporter before you dismiss the court reporter.
That's great. So I'm going to take a session.
Okay.
So you, is that, really? Okay.
It hasn't been voted on, so it hasn't been passed.
I'm sorry.
No problem. No, that was discussion.
So the motion was made by Sammy Bomay,
I second.
second by Martin B. Smith, all in favor? Any opposed? All right.
So now that, and I think we kind of jumped, but now that we have guidance on what the policy should be for the appeals, we can meet with the clerk to see how she will enforce those policies. Anything else in regards to case updates? Was the motion to go into executive session immediately after that update or total updates?
Yeah, it's a couple of days.
So the next update is the Senate Bill 22 that you all have in front of you all. As you know, this bill was written by Senator Jones and it was co-sponsored by Senator Strickland, who did not retain his seat. That does not stop the bill. Because Senator Jones is still in his seat, he's still able to do any amendments or such that he so chooses. You all asked me last time, or someone asked me last time what those amendments were that we were asking him to make. I included a hard copy for you all so that you all can see them. I couldn't remember who specifically yet, so I just included a copy for everybody.
Yeah, but okay, I see it.
I have a question. Based on what you just said, so if both senators are removed, this bill is in jeopardy?
No, so we were reaching out to Senator Jones as the drafter to get amendments, but it's already made law. It would have to be repealed as law.
I just want to make sure. That's about.
We need another sponsor or co-sponsor or.
Usually you don't.
Okay.
It just looks better to have a co-sponsor because you're able to work across the party line,
Right.
but you don't have to. The second thing that you all have before you all is updates to the rules and procedures. This is something that you all tabled. I will go through those updates so you all can see what I am proposing. These are strictly proposals for you all. If you all want to see any further updates, we can include them. If you all want to take some out, we can do that as well. The first update is actually defining what the code of ethics is. We use it throughout the procedure, but referring to Senate Bill 15. So that's in the definition. The second major update, some of this is just, it's grammatical, but the second update of substance is 3.5, the term of office. Bree brought it to my attention earlier this year that there was a conflict between what the code said and what our procedure said. So what I did was I referred to the code specifically. So I just incorporated the code so it would not be a conflict. Now, I was notified today, Gloria said that when our alternate members were sworn in, they were sworn in with a date to begin technically on January the 1st, 2025. The clerk was given their term dates. Their term dates are supposed to stagger. And one actually is supposed to begin in February, which replaces Ms. Burrell. And then the other one is supposed to begin in January. But when she did the oaths, they're not right. Because we needed our alternates, they went ahead and got sworn in. But I do believe that we need to go back and fix those term dates, because if not, it's going to throw off the way that the initial terms were set for the code. Yes.
When I was sworn in, for District 4, my term date is incorrect as well. We can discuss, but I'm supposed to finish a term of the previous chair or the representative for District 4. However, my expiration date is not until 2027 on my swearing in.
Mine is the same.
So what we probably need to do is, look, I have a chart with everybody's term date. And I went all the way back to the original members of when they should have fell off and who was to replace them. We need to ask the clerk to amend the oaths so they can be in compliance of what it's supposed to be.
Can be, well.
Hmm?
I mean, well, yeah, it's an error. So my question is, can the grandfather due to the error, the individual?
In what way? What do you mean?
What way is make it as it is, unless you have issues. That way we don't have to have this turmoil as far as conflicts and dates. It's at no fault of the individual or the error. So my proposal is we leave as is and we make the correction moving forward.
I would probably defer to general counsel on that, because the law set out how the dates are to be defined. So I would ask general counsel what her thoughts are, because if you all change it, it will conflict with how the code already had it set out.
No, I'm not changing. I'm grandfathering those individuals because of the error. So
If the
basically,
grandfather would, if the grandfather doesn't change it per the statute, I think it would be fine. But if the grandfather would have it anything less or more than what the statute would say,
Okay.
then I believe it will be a problem.
okay,
So I think we probably just need to see what those dates would look like. 3.8, I corrected that. Initially, it said that a board member could be removed by a unanimous decision. The code actually says a majority of the decision. So I just, again, made it more in compliance with the code. .15, you'll see a big delete there. We had a language regarding to recusals, and a party proceeding had to file a motion to recuse. We really don't have to have that now, because the hearing officer asks you all before each and every hearing, do you need to recuse? And you all do so, and you all actually do so before we have preliminary hearings. Yes.
will that create a problem if there are recusals and we don't have a quorum?
Yes, it will create, which is why we have alternates. The two alternates are meant to serve in place of recusals. So we will maintain a quorum.
At the date of the hearing, that's when this is going to be implemented. So what if we don't have enough at that date?
It's implemented at the probable cause hearing, so we'll know before then.
Okay.
You all actually really will know at the time that you get notice of the complaint, because you can look at the complaint and see the parties, the witnesses, and all of that nature.
Question.
Mhm.
In the event they bring counsel or a representative, should we then be also notified? We sometimes aren't notified at the time that we decide probable cause. So on the day of hearing, we may run into a conflict if in fact their representative is someone that is also our representative or friend or relative. We circumvent that by having our alternates there on scene for hearings, right? They're present for each.
Correct.
Okay.
Your alternates are just as a board member, they attend the hearings, they attend all the meetings, because if there's a pop-up situation like that,
That's what.
one will move into the place.
Or is it a way that they can advise us if they have counsel prior to the hearing?
I don't think there's a certain way they can do it, because you have the right to counsel and you can show up day of with counsel.
Right, okay. I guess I just don't want it to get to a point where it happens the day of, and let's say some of us might be out, you know what I mean? And so it would To me, it would just be better for them to advise us like before, like, okay, hey, we do have an attorney.
It's best in practice, but I don't think legally you can mandate them to give you notification of counsel before a hearing. They have a right to counsel at all portions, including day of.
I feel like most attorneys would give an
Entry of appearance, too.
I mean, unless they're
Would they have to get
engaged at the last minute.
They don't have to.
I know when they retain an attorney, do the attorney give us notice that they've been returned, they represent the individual?
They should, but they don't have to. So the point of an entry is to make sure that you're receiving all notifications of a hearing and that you're entitled to the process. Them showing up day of with counsel, they pretty much waive that process. So it's to their own detriment, to be honest. But we can't really say you can't have counsel unless they file an entry beforehand, because they have a legal right to still have counsel.
So even if they do that, wouldn't it be, could they somewhat kind of halt the proceedings the day of if they haven't been privy to everything that you?
Nope. So that's when the board's discretion come into play. So if someone showed up day of with counsel, and they chose to show up and now the council is asking for a continuation, the board has the authority to deny the continuation, and the board has done that. When Thomas hired a council, I think 3 or 4 days before a hearing, chair decided to deny it because it had been set. Yes,
Is that a reason for appeal?
no. That's within the discretion of the board.
Technically, really, anything can be a reason for appeal.
Oh, yeah, technically speaking.
Because if they come in and say, I couldn't afford counsel, and I couldn't afford representation, and as a retainer required, I get paid on Friday, hearing's not to Monday. And I could retain counsel until, or if the hearing's on a Friday. So we have to be mindful of the idea of it being going to appeal because of that, or asking for a continuance and us denying it is possible. It's a matter of what happens next, but.
And remember, these are quasi judicial, so they can appeal for any reason.
Correct.
I mean, they can appeal because they didn't like your blue shirt that you wore that day. They don't have any specific reason. So whether you continue it, whether you deny it, either way, they can appeal.
I think we do, I'm sorry to interrupt. But I think we do, as far as continuances, don't we have the one courtesy continuance?
As a practice matter, that's what the board has been doing. It's not a rule. I would not suggest making it a rule. But as a practice matter, the board has been granting one continuance when the board has been properly notified with enough time. Because the problem is, one, our rooms are very hard to reserve. So once we reserve a room, we have reserved it for at least 30 days out. 2, we have to reserve the court reporter. And then 3, we have Casper's, which is our hearing officer that travels. And so the continuations that have been granted granted because they requested it so far in advance, we had time to cancel and reschedule things. Any other questions? Yes.
So you're turning it to me, good.
Is there any requirements that we provide to the individuals, letting them know that if they retain an attorney, they should notify us?
No, because that's the attorney's job. So we don't tell them, if you retain your attorney must notify us. Attorneys legally have an obligation that once they've been retained to notify whoever it is by way of entry of appearance that I've been retained. Now, some people just don't, they just retain attorneys late. Sometimes they'll retain them Friday for a Monday morning, or the attorney may not be able to notify you until they show up on Monday morning.
Okay, so that leads me to my other question. So is the attorney properly prepared to defend this individual?
Right.
I don't know, but then you come into the question, that's not the board's problem, because hearing notices are sent so far out in advance, more than 30 days really, that if they waited to the last minute, then that was their choice to wait to the last minute. They could have retained an attorney anytime within the process. And most people, if they're gonna retain, they're usually talking to an attorney after probable cause, before they got to the formal hearing. Because remember, once you all have that probable cause, they're notified within 48 hours that it's going to a formal hearing. So they may not have the formal notice until 30 days, but they've had informal notice for a lot longer.
Okay.
On 6.1, it was updated to include county manager. Just for closure purposes. It only said governor, but there's been times like when we had the hurricane, the county manager closed county offices, so that was updated as well. And I'm trying to go high level. You all certainly can take it with you and review it further. 6.10 or 6.10 was updated with the statute because that updated. Most of the updates come after 8.1. So 8.9 clarified that the conduct of the evidence standard is at a formal hearing because the standard is probable cause at a preliminary hearing. 8.155 is what the board asked me to update. Instead of 3 days to exchange things, it will now be 7 days to exchange things. 8.160 talks about the deliberation process and that the board has to either dismiss the case or impose a sanction. Those are your only two options. 8.161 talks about the, yes.
Just for clarification, when you say impose extinction, is the opinion extinction or is it something else? Advisory opinion?
It's something totally different. By the time you get to the formal hearing, you only have two options, dismiss or sanction. An opinion is just that, it's an opinion separate from any hearing.
I guess I'm a little confused.
Mhm.
So you're saying in deliberation, we cannot do a advisory opinion?
You can't do that as a form of closing out the case.
Okay, gotcha. Okay.
We just do it like this little,
Mhm.
just an add-on, just.
Okay.
If there's some things that we couldn't, like how we did it last time, we couldn't really come to agreement. With some things, but we did agree like, okay, hey, something has to be said or done, so,
So the remedy was the dismissal,
right.
Gotcha.
and then
Okay.
the add-on was the opinion.
Yes, I got it. Thank you.
No problem. 8.161, that's the continuing. This is where I propose some language. You all feel free to tell me what you think about it. And it just clarified that the board will not delay or schedule hearings, that if there is a request for continuation, it need to be done at least 3 business days before the scheduled hearing. And failure to make a request within 3 days should constitute an automatic denial. And that goes to we already kind of reserve rooms. Now, again, if the board wants to take some of that out, that's totally up to you. I kind of throw it all up there in there and you all can discuss what you like and what you don't like.
I think maybe just for continuity, 7 days, because we're asking for 7 days. Make sure that we've exchanged any exhibits. I mean, 3 business days before any scheduled hearing when you've had at least 30 days notice, barring death or dismemberment. I mean, how much notice do we have to give as far as reserving the room? We're reserving those, how far in advance?
30
Months.
Months in advance.
And by the time we're looking at, we just asked the county for a room, for dates for a room for our ethics forum. They're already giving us dates in February. We're in November.
Well, obviously, there are more reasons why you would granted continuance besides death of dismemberment. You could be in the hospital, you could be arrested, you could be out of the country. You could be sick and we don't want what you have. You know, you could be receiving treatment for an illness that could be possibly deadly. So I guess my concern is that we kind of just spoke about the continuance and the idea that they could arrive on day of and ask for continuance if they've not had proper representation. Here, however, we're denying it technically from the start because we're saying if it was not received 3 days prior to the hearing, it's automatic denial. So technically, it answered the question for us. It just denied it for us.
Well, it says absent good cause. So, I mean, obviously, any kind of, if you're ill or anything like that, if you decide, wake up one morning and decide, oh, I feel like going on vacation.
I just want to
No.
trust what you just said.
I want to hear what you're saying.
The whole concept is that you have to request it and it has to be denied for you to appeal it, regardless of what they say.
Or would you all like to keep it at 3 or 7?
No, the 3 is fine.
Keep it at 3?
I think so. Anyone disagree?
I mean, that,
Yeah, what about with the court reporter? Like if we have to cancel her, how many, are we 24, 48 hours?
Usually it's 24 hours without a fee. Most of them are typically 24 hours.
And the same for Casper's.
Casper doesn't have a cancellation fee right now. I would not be surprised if that's something he may bring up, and he has said it to me in full transparency in the future, just because when we schedule a hearing, he blocks his whole day on his private firm. And I can see how that could be an inconvenience to him. 3 days, 7 days, which would the board prefer?
Y'all comfortable with 3?
3? Okay.
I mean, that's the way it's worded, absent good cause. I mean, I think that pretty much encompasses anything that would, if somebody were ill, if someone, if there was a death in the family, in prison, like, because if that were the case, they're not going to be able to make a written request for a continuance anyway. And I think as a board, obviously if someone is in the hospital, we would certainly not expect them to appear for that. That's obviously something that we would give some grace on. And I just think, in the past, when we have had requests for continuances, they have been sent to us almost immediately upon notification of the hearing. My biggest concern there is making sure that we're not incurring any costs by having to pay a court reporter for, her not being there, not giving her enough notice or Casper's, that sort of thing. But as long as there's no fees like that, I'm fine with it.
leads me to a question about this then. So we did not issue a continuance and the individual does not show up. What's the remedy?
We have that somewhere in here, but the remedy is to proceed without them present. I have it somewhere in here. That's typically how the courts do it. You don't show up, you lost your opportunity to negate anything that's being brought. Just proceed.
And it's spelled out.
Somewhere. It's a failure to appear and failure to show. We're gonna get to it on 8.165. Anything else on the continuum? Yeah.
I'm not continuance, so sorry, go ahead.
On witnesses, the 8.162, we talked about not only exchanging evidence, but also exchanging a list of witnesses. Because there was a potential issue last time on whether or not the respondent can be called as a witness. I added that language in here as well.
Where's that?
It is the second sentence in witnesses. The ethics officer may call the respondent as a witness. So there is no question on whether or not they can be called.
And didn't we cover that as well? And when we send the notice, it's technically a subpoena as
Yeah.
well. Okay.
Mhm. So it's covered twice.
Which line item is that?
Here.
Okay, I see now. Okay.
The next one is 8.163 witness fees. I'm sorry, go ahead.
No, go ahead, because that's what my question is about.
This is the witness fees. I think general counsel may, touch on, subpoenas, so I'm gonna skip that for now.
Okay.
But when she touches on that, I'll just tell you my rationale for adding the language is we talked about previously, people abusing it, like pro se parties abusing the subpoena power. I know with the Superior Court clerks, you have to pay a witness fee. So it's a nominal fee, I think is, oh gosh, I don't recall off the top of my head. It's not more than $25 per subpoena. And it's for purposes of, I think, so people don't abuse the process essentially. But I'm gonna let general counsel speak more to subpoenas and her position on what to do about those for pro se parties. For 8.164, the request for any virtual appearances be made within 7 days and on granted for good cause, so that gives the board some discretion. 8.165, that's the failure to file an answer and appear. The respondent's failure to file a written answer and failure to appear at a properly noticed hearing shall constitute omission of the factual allegation. So this is one, some of you all tell me how you want to go. Some people love it, some people hate it. This is technically how they do in court. If you don't respond, it's on the default. You didn't, especially if there is, or only when there's proof of service. So you still got to prove that they have been properly served. But if you don't respond, you don't appear, then that's an omission of factual allegations. Yes.
So we carry on with the hearing. So I guess you're going to say and tell us that this individual was properly served and so on, so that we know that, correct?
Correct. Tell you when they were served and how they were served. And the thing about these types of proceedings is if you're not there to refute them, then everything that is presented is taken to be factual.
Okay.
Now, if you notice, it's a failure to file, answer, and appear. Typically, if somebody files an answer and don't appear, then you still have to almost prove your whole case. If they don't file an answer and they don't appear both together, then that's deemed to be omission. Yes.
Okay, so my question is, when they file the answer, we are provided that answer to review and still the case is presented, correct?
Yes, correct. So when, yes,
No, go ahead.
so when the answers are filed, Gloria emails them to you.
So the admission of guilt in a sense, how can that be? If we're gonna continue with the hearing and you're gonna, present the respondent, is it really the burden of proof to prove that what the allegations are true or disprove them to be, because if they're there just to respond to the allegations, isn't it the burden is on the person bringing the allegation to prove and bring sort of the evidence? And then as a board, we take into consideration it all. So by default, it isn't their admission of guilt and we automatically decide now to sanction them. It is a process that still happens with them, with or regard without it.
And that's why some people love this rule and some people hate it. So bar complaints, I'll give you an example, right? If somebody filed a bar complaint and you didn't notice that a bar complaint has been filed against you, if you do not respond, that's automatic omission. You don't have to, the director of the investigation doesn't then have to prove that you did whatever was in your bar complaint. It's just automatic omission.
So I don't like it.
Okay, so you all want to take it out?
Wait a minute, I have a question.
Mhm.
What constitute a reply?
Answer, so they could send Gigi an email and say, I deny the allegations. They can file it formally. some proactive response to the allegations made. So by way of an example, the case where we had with Thomas, her first response was, you all can't move forward with this case. I'm in the middle of an election. That would not have been deemed an answer because it does not address any of the allegations. But if she would have responded and said, this is not true, I deny it, Gigi would print that and stamp it as their answer. We're not as stringent as the court system where it gotta be formatted just right. We have to just understand you're denying or replying to the allegations.
But if the folks that are alleging X, Y, and Z happened and they read our procedurals, rules and procedure, they're understanding that now I can come here and just wave and say hi because whatever has been presented is assumed to be them being guilty of. No?
I take it as that we're saying that information is factual. We still have to decide if it's a violation or not.
We would still have
Get that.
deliberate, we would still have a hearing and still have deliberations based on the evidence that the complainant presented us. Right?
So when it's deemed factual, that means it's deemed true. So at that point, it is more so admitted.
It's an
And then
admission.
you would have to go to those
Like it.
two issues. You would either have to dismiss it or you would have to impose a sanction.
Okay, one thing. Let me,
I don't think I'm gonna like your response.
no, it's not. Two things actually, but I can't remember this stuff. Well, let me just, before I forget both of them. So this failure to file an answer and appear is after they have not issued a continuance. So they had the opportunity to file a continuance, they did not, and now they're not appearing. That's why I was asking about this.
So if at any point they fall ill or incapacitated, so in other words, they're not able to communicate.
Okay,
And so if they don't have someone communicating on their behalf, then something could have happened, horrendous to them, or they, for whatever reason, and they didn't respond within those 3 days of the hearing.
Mhm.
And they've not given this or appeared. Still something, I don't think it's fair. Because, this whole point of innocent until proven guilty, I prefer that method than assume guilt based on your lack of appearance.
I don't, this does not contradict as far as the case itself. You have the right to have a case, a trial. However, what this is saying is that you did not have, let's just use your example. If you are sick, you have a trial. You give a friend or family member, call.
So if they're on a breathing machine,
Okay.
so you get what I'm saying? Who they gonna call?
And
Like, and I'm gonna give an example.
Mhm.
I was incredibly sick, couldn't breathe. If I at some point would have been hospitalized, you weren't gonna get that call. And if no one is privy to the information of my life and understand that this exists, how are they gonna then notify you?
I agree with you. However, problem is you didn't show up and we have a case. Now, that may or may not be appealable.
Right.
What you just explained, and that's up to you to appeal because of that.
But then if we issue a sanction and then we go and we put mud on their name in public, and then now we've accused them, sanctioned them for something perhaps they're not guilty of because they didn't have the proper opportunity to present their case. And I get the appeal process exists. We're just agreeing to disagree.
No, I understand.
Yeah.
But there.
No, I still disagree with you.
No. There are some cases where it's going to be a situation where, yes, that is true. However, I'm
You're
assuming.
far and few.
Exactly.
Yeah, but we still disagree.
Yes.
Yes.
We do.
We
And
still.
I think when I put this language in, you all know me, I kind of go county, different states, see what everybody else do. Hone in on my experience with the court system. And this is one of those things that if we take it out, it doesn't hurt anything.
I personally feel like the biggest, this is going to come into play for people that no longer work for the county and don't want to be bothered. They get notice of it. They like, I don't work there anymore. I don't care. It doesn't matter.
Subpoena power. They can't not show up once there's a subpoena. Well, I guess we'll get into that discussion.
Well, this is subpoena power too.
Listen, did we not disagree already?
So. Except for you must appear. This is saying, after getting notice that you must appear, if you still fail to appear, then it's taken factual. So typically in the judicial realm, the onus is on the respondent. And I guess the theory or the logic behind it is if it's important to you, you're gonna proactively do something. By the time we get to a final hearing, we're probably 6 months in. If you haven't filed an answer, nor did you show up in 6 months of time, then most of the time judges say, well, we're not gonna waste our time hearing this because you didn't care. We're just gonna deem it to be a factual admission. And here is the result of it. But again, we're quasi judicial, so it doesn't have to be there. That's just kind of how they do.
I thought we were gonna expedite the process a bit and not linger so 6 months is.
It depends on rooms.
Yeah.
Until we can have a place where we have dedicated access and can get rooms quicker, we're always subject to what the county can give us.
So,
Do we always have to be at a county location?
No,
Okay.
we can rent something, but then we go into budget.
We coming to your house?
Is there any way we could insert the same language of absent good cause into that? Because then, I mean, like you're saying, if someone, fell ill or whatever, then I think that would still address the people that are just gonna ignore it regardless. And you would also have that in their absent good cause for missing it.
But in theory, if we could actually get called, the thing would have already happened. So they would have already missed the hearing, the board would have already deemed it factual. You
Yeah.
already would have issued a sanction and their remedy at that point would just be an appeal.
yeah, you have absent and good cause in the continuance. So if you can make that absent and good cause don't matter here.
I think you're saying by this point,
Mhm.
at the very least, you should have made a request for continuance.
I still have a question. Let's say we hypothetically remove this and we do not have this language. What happens then if they do not show up?
If they don't show up,
Yes.
it still proceeds as a regular hearing.
So this, to your point, this really is gonna happen.
No, the hearing proceeds, but the admission of factual allegations.
Well, that was
does not.
Got it. Okay.
So you see what I mean?
So this is, if you all wanna think about this one some more, you're more than welcome to. I don't think that tonight will probably be a night that you all vote on the totality of it, but I wanted to at least explain to you all the rationale of each change. The next one is 8.166 failure to disclose. And this basically gives the board the authority to deny myself or the respondent the ability to call a witness that they did not properly disclose. Sometimes people like to hide the ball and play the surprise game. This is not what this process is supposed to be like. And so if they want to say, oh, we have this magical witness that we found last night at 12:01 that we didn't tell the ethics officer, the board has the authority to say, no. However, if they say, I didn't know of the witness, here's a circumstance that came about, you can hear that too, and the board is allowed to say, yes, it gives you discretion.
Can I revisit 8.165 again?
Sure.
Now that I know your issue with this, is the shall constitute an admission of factual allegation, correct? So can we make that at the discretion of the board?
If you want.
I like that. I can give that. I like that.
And I think that actually would give the board more autonomy on a case by case basis.
I have a question, but I'll take this back.
Okay.
Okay, because I know, you asked earlier. So 8.161 on continuances, how do continuances happen? Is it the chair and the vice chair get together and decide if there's gonna be a continuance, or it's the whole board who needs to?
So typically it's the chair.
Okay, okay,
When the things, they usually call those almost like administrative things.
okay.
Typically, the chair decides whether or not a continuance is granted or denied.
I'm good. Does that need to be spelled out, or? Because it says the board.
Well, it says the board, but your chair is always your spokesperson.
Okay.
Now, how the chair chooses to do that procedure would be up to essentially the chair, which is why you all voting in chair. If the chair says, hey, well, I want to discuss it and get a vote from the board, the chair can. If the chair says, I'm just gonna make the decision now, so we keep things moving, the chair can. It's totally up to the chair.
Okay. The only reason I started questioning it is 3 days enough if we have to vote, come together to vote on it. That was my.
Mhm.
But if
That would not be enough.
Okay, so if the chair is making that decision, then I think it's fine. Okay.
The next one is, the subpoenas. I'm going to skip that until that is talked about in the council. The last major change is 8.18. That's the conflict notices. So when people have attorneys typically have to be multiple places at multiple times. It didn't get to the board, but the day we had Munez, that attorney had 2 other hearings on that same day. And it didn't have to become an issue of this case, but he had a criminal case at 8:30 that would have superseded this case. The language I added said that failure to file a proper conflict notice pursuant to the Superior Court rules constitutes an automatic denial. The Superior Court rule says that you have to file a conflict notice within 7 days of a hearing. That 7 days gives the board enough time again to, if you need to cancel it or reschedule it. Now, I don't think we can completely say an attorney can't file a conflict notice because a person has a right to an attorney. If the attorney has a conflict, then they can't be 2 places at once. But the attorney, we can say that you have to follow the Superior Court rules, and if you don't, we're just gonna deny automatically. Yes.
Can we add the language in here that states the respondent's counsel or attorney for respondent? Because with it just reading conflict notices, failure to file a proper conflict notice, anybody that's representing themselves may say, oh, well, I have a duty. Yeah, I have a doctor's appointment that day or whatever. Just to clarify that is meant for parties that are represented by counsel.
You just put counsel there, counsel, conflict notice.
Mhm.
Yeah, that would be fine.
The last change is the change we just talked about under 9.3 appeals. This lays out the procedure for appeals, so it says all appeals shall be governed by an enhanced code section. I did add some language about any monetary sanction that was issued shall be paid into the court's registry. And within 30 days, it shall be dispersed by the order of the court. And the reason I did that is somebody asked the question in one of my trainings, what if I'm sanctioned and I want to appeal, do I got to pay the money? Well, typically you still have to pay the money, but I don't see it being a good situation where they pay the money into the board, it goes to appeal says, hey, board, you're wrong, and then the board has to cut them a check. I think it's a better suited situation if they pay it to the court registry and the court holds it, and whatever the judge decides, either it comes back to the board or it goes back to the individual.
Mhm.
Yes.
So how long? Well, what is the procedure for them once they have the fee? How long do they hold the fee? And at what point past the date that's supposed to hold it, do they turn it over to the board or the county?
The court holds it for as long as they have to hold it until the judge issues an order. There's no time limit.
No, the reason I'm asking is because they have a limit for appeal, 14 days.
So who holds it, the court or the person?
No, if they're paying the court, they have 14 days from the date that they pay, I guess, to appeal.
So the 14 days is being trumped by the statute now, remember? So, and they have to pay it within 30 days of the sanction. That I have that on here too.
Okay.
So if you look, it says that, any monetary sanction issued as a result of the board's decision shall be paid to the court's registry within 30 days. It shall be dispersed by the order of the court. You did.
Yeah, well, I see it, but I'm just saying that we have to change our notice then. That it's filed, because on the notice it's 14 days.
Yes, now that we have the statute and notice of the statute, we will have to change the number, correct? And what we would do is take out the date and reference the code section. Because again, codes change, so I like to just say, here's the code, you have to check that. Because I don't want to put it 14 days and then the legislators change it and now it becomes 45. So we just give them the code section.
Thank you. So it goes back to my question. So 30 days, they hold the money. Is it automatic or do we have to go back and talk to the courts in regards to disbursements of funds?
So the court issues an order.
Okay.
So once the court issues the order, they give it to the clerk. The clerk has to issue the payment. Now, how long that process takes, I have absolutely no clue. I've never seen it. Any more questions? Those are all of the major changes. I encourage you all to review it. And if you all see other changes that you want to add, you want to take away, or you don't understand why it's there, please let me know. I would like to have this updated and changed, voted on, be enforced at the beginning of the year. That is all the business that I have before the board chair. Yes, ma'am.
We're gonna go to council now about the subpoena process, or let's set later. So you would go into executive session.
Thank you. Motion to go into executive session.
So moved. I make a motion.
Motion made by Valerie, second by Blaze. Lee.
I was gonna say.
All in favor? And executive session.
Mom?
All right, we're out of executive session. Last item on the agenda is to adjourn the meeting. If I can get someone to,
Motion to adjourn?
A second.
all right, motion made by Sandra Ball. Second by B. Smith, all in favor? Any opposed?
I have motions.
I'm sorry, Phil.
There was, well, I think there was a request from Attorney Bullock for us to review this and get her.
Oh, I'm sorry.
Okay.
So before we,
The deadline. What would you all like to review? How much time do you all need?
you said you.
Well,
I'm sorry,
let me
motion back.
rescind my motion.
A motion rescinded to adjourn. Sam,
Yes.
second by Vice Chair. So the discussion is when we're gonna have the updates, our own individual updates for the bill of the rules and procedures.
Is it both? Attorney Bullock or just one?
I think y'all gotta vote on the motion to
If you
rescind.
have to vote.
Oh,
Did that.
I don't.
you just
So
said.
rescind it. All in favor?
Okay.
Mhm.
Oh, but
We're
we're
back.
back.
So for the rules and procedures, if you all can have that to me at least a week before the next meeting, I'll make a clean copy with all the changes. And if that way, at the next meeting in December, you can vote. For the,
But that would be December 3rd.
yes, if that's what, yeah, I don't have one, but December 3rd, yeah. And then for the Senate bill, if you, it's kind of up to you. How much time do you all need to review it? Today is Tuesday, do you all need through the weekend? Because I can get it out to the senator first thing next week. If you feel like you can tackle it over the next couple of days, I can get out for the end of the week.
Yeah,
So when can you all have your review and commentary?
I feel like I could get it done by Friday.
I can get it done by Friday.
Right.
So here's the thing, if you all get it done by Friday, I will get everybody's review and commentary together. But if there's any questions, they'll probably won't go out to the beginning of next week. That's fine? Okay.
Question, how do you want the review back to you?
Would you all like a word version, track changes?
I would prefer Word.
And I think I would double check, but the document that I also sent you all was Robert's rule, the cheat sheet. Everybody should have gotten that in your emails from work.
It's good. Right. You get motion to adjourn.
You entertain my motion to adjourn.
Second.
Made, Sandra Ball made, second by Barn B. Smith, all in favor? Any opposed? Meeting is adjourned.